We have a new Companies Ordinance which has taken effect this year in March 2014. The whole company law rewrite exercise actually started back in 2006, and now we have a completely new Companies Ordinance in the sense that we have a dedicated chapter of ordinance dedicated to it, which is the chapter 622. In the sense that it is new because in terms of the expression, the way that it is written, it is now much more modernized, and we have new concepts, new terminology, which is very different from the old chapter 32. Basically, the new company ordinance, it replaces almost all provisions in relation to companies except for insolvency provisions, winding up provisions, and provisions regarding prospectuses. And we expect that those provisions regarding prospectuses will be moved over to SFO, the Securities and Futures Ordinance, later. So what is left behind in Chapter 32 would be those regarding insolvency and winding up. Reason for having the new law, we understand that the last time when we had such a significant revamp of the company law was like 20 years ago. So this itself is already a reason why we need an update of the law. The objectives of having the new law is essentially to enhance corporate governance, to have better regulations, and to facilitate business, make Hong Kong a better, more attractive place to do business, and to modernize the law. Yes, there are initiatives under the new Companies Ordinance which I think would help Hong Kong to be an even more attractive place to do business. For example, in terms of equity capital contribution and withdrawal of equity capital, nowadays it has become more flexible. And in terms of execution of deeds by a company, the new Companies Ordinance has offered more options, so again, a higher degree of flexibility. In terms of corporate governance, it strengthens the accountability of directors of a company, so which means from an investor's angle, it offers a higher degree of transparency about how the company is managed. So on the whole, I think from investors' perspective, it would become more attractive, and it is in line with the international standard of other investor-friendly jurisdictions. The new Companies Ordinance has taken effect as from March 2014. All existing companies incorporated in Hong Kong and new companies, they are all subject to the new law. So technically speaking, in terms of the law taking effect, there's not a transitional period. There are deeming provisions in the Company Ordinance, which means that existing company, they do not need to take any immediate actions in order to get in compliance with the law. But because there's so many fundamental changes, directors and company secretaries, they need to be on top of all these changes in order to make sure that the companies would continue to be managed in accordance with the new law. One thing to note is under the new Companies Ordinance, each company, in terms of private company, it needs to have at least one natural person director. So in case currently a private company only has a corporate director, it has 6 months transitional period to appoint a natural person director. In the new Companies Ordinance, one of the major changes is the abolition of par value in relation to Hong Kong shares. So this is a major change under the new law. It follows that because the par value has been abolished, share premium account and capital redemption reserve are also abolished. So these concepts are no longer applicable under the new law. Share premium account and capital redemption reserve, they will be treated as issued share capital in the future. Again, another result of abolition of par value is nowadays when we want to increase share capital, so it's possible to increase share capital without allotment of shares because par value has been abolished. The other way around, it's also possible to allot new shares without increasing the capital of the company. So on the whole, share capital has become more flexible. Accounting-wise, it's less complex because we have a few less technical concepts, and the share capital structure now is more flexible. Another major change is in relation to execution of deeds by Hong Kong companies. The practice is now modernized. Before the NTO, every Hong Kong company must have a common seal. The use of the common seal basically is for execution of deeds. Under Hong Kong law, agreement that is not supported by consideration will need to be executed on a deed, and there are certain special documents that need to be executed on a deed as well. For example, an assignment of property. Under the new law tells us that it's no longer absolutely necessary for a Hong Kong company to keep a seal. So it's optional. You can choose to keep a seal, as you had done before, or dispense with using a seal. So in terms of deed execution, you could use the traditional way to affix a seal and execute a deed. The alternative way offered by the new Companies Ordinance is a deed may be executed on the hand. That means directors or authorized person, they could simply sign the deed on the hand to give effect to it. The only thing that you need to be aware of is make sure that your article of association do not contain restrictions from you. Restricting you from taking advantage of the new law.